When do you want?
On 24th.
Okay.
My lord, field officer matter. These are pending schedule documents. Next week, my lord.
Give a date. Put a date.
Tuesday.
Okay.
May it please before your lordship. Lordship, with the consent of the other side, I beg to mention item number 9 on the daily list, lordship.
Yes.
As per lordship's convenience, lordship may fix any date in the next week, lordship.
Okay. Yes.
My lord, item number 9, we have some clarification to make. My lord, the matter is intensely important. Pension matter, my lord, and more importantly, the petitioner's wife is in deathbed. And the petitioner himself is 80 years old. My lord, maybe on Tuesday or Thursday, my lord. Next
When do you, Tuesday?
Tuesday, my lord.
Lordship, the standing council is out of station today, lordship.
Huh?
I'm appearing on behalf of respondent number 1 and 2 on
Yes.
behalf of G. Boras is out of station today, lordship.
Yes. So when is she?
Next week, lordship, Tuesday.
That's why Tuesday. On the prayer for adjournment made by Miss
MSB Chetri on behalf of
MSB Chetri
on behalf
on behalf of
of MSG Boras, standing council for respondent number 1
MSG
and 2.
Bora, learned counsel for the respondent number 1 and 2.
Yes, lordship.
List the matter on Tuesday.
Obliged, your lord.
Obliged, lordship.
May I please, your lordship, with the consent of the other side, I beg to mention item number 7.
7.
Right.
Yes.
My senior is ill, so
Okay.
maybe on after 2 weeks time. If lordship
Who's the senior?
and Sarkar.
On the prayer for adjournment made on behalf of Mr. N. Sarkar, learned counsel for the petitioner. List the matter after 2 weeks.
Please take the lordship. May I please, your lordship? I wish to mention item number 3, my lord.
Yes.
I pray for one adjournment of the case.
Huh?
I pray for one week adjournment.
1 week adjournment. On the prayer for adjournment made on behalf of Mr. S. Bhattakur. List the matter after 2 weeks.
Okay. May I please, your lordship? I am listing for WPC 7104/2021 and they allow for next week,
Okay. What date?
What?
When?
next week.
Next week? Which date?
Okay. May I please, your lordship? I beg to mention for listing, my lord, contempt case 5.
When do you want? When do you want? When?
22.
Okay.
And another one is the contempt case for 559/2023.
When?
22, my lord. And another one, WPC 5586.
Okay. Since you already done, no discrimination can be allowed.
May I please, your lordship.
Yes.
The matter relates to the pension claimed by the second wife.
Fair enough.
So notice may be.
Basically, second wife is entitled.
The second wife is entitled and then she had the claim that the Junufa baby case is
Ah.
there, your lordship.
So we can dispose it off with the direction that let the authorities verify whether you are the second wife.
Yes.
If you are but then the payment will have to be made only to the first wife.
That is the
And
landed by judge.
Then the portion of it will be given to you.
Yes.
So that we can direct.
Yes, I have.
Otherwise, issue notice at the end, the
Yes,
same
yes.
order will be passed.
Yes, I am really suffering, but if I get any.
है ना? I think that's the only. But of course, personal hearing has to be given to the petitioner and to that both. Just in case
Yes.
she disputes.
Yes.
Right. Heard Mr. S.C. Biswas, learned counsel for the petitioner. Also heard Mr. S.
CS
C.S. Hazarika, learned counsel for
The respondent 1 and 4, your lordship.
1 and 4. And Mr. N. Upadhyay for
3, lord.
respondent number 3.
Fine.
What about 2?
2,
Finance?
2, 5 and 6 are finance, your lordship.
2 and 6.
2, 5 and 6.
2, 5 and
Oh, no, 2 and 6. 5 is 8.
who do finance? Yeah, for the AG,
This one number 5.
Mr. D. Rabah appears on behalf of A. Hassan, learned counsel for the respondent number 5. Then finance.
Someone comes, then your lordship will insert the name.
Mr. Dash appears for respondents number 4, 2 and 4. Who is for finance? Yeah, Mr. M.
We are lordship.
M. Bhuya on behalf of
B. Google, lordship.
B. Gogol. treasury officer also,
Treasury officer. Oh, yes.
right? The case of the petitioner is that the respondent number 7 is the first wife of the late Jabar Ali Sarkar, and the petitioner is the second wife. Full stop. The petitioner's husband retired from service in the year 2004 and was availing pension. He, however, expired on 11/7/2023, leaving behind the respondent number 7, the petitioner, and two children that was born with the born with the union with the petition. Next paragraph, the petitioner's counsel submits that the petitioner, being the second wife of the late Jabar Ali Sarkar, the petitioner is entitled to a share of the family pension, though the family pension would have to be paid in the name of the respondent number 7, in terms of the full bench judgment of this court in the case of MUSTT Junupa Bibi versus MUSTT Padma Begum alias Padma Bibi and 4 others, WA 160/2018. The petitioner's counsel thus prays for a direction to be issued directing the respondent authorities to pay a proportionate share of the family pension to the petitioner as is being given to the respondent number 7. But that cannot be done.
Proportion?
That full amount will go to the
First wife.
respondent number 7 and then she will give you
She'll give you 50%.
50%. Right. Next paragraph. The learned counsels for the respondents submit that the issue whether the petitioner is the second wife, submit that they have got no quarrel with the prayer made by the petitioner's counsel, insofar as the petitioner would be entitled to a share of the family pension, provided it is not disputed and that the petitioner is the second wife of the late Jabar Ali Sarkar. They accordingly submit that the who should look into it? Huh?
That's
The
not
court-
5 kg. That's not 5 minutes. Account general.
No, it'll have to be the department.
Yes.
Which is your department?
The irrigation level, commissioner secretary.
Accordingly submitted that the rest, but which is that you are in the directorate or what? Better, I think. You have not made the directorate. of what?
Lordship included the executive engineer concerned.
But that is not, he's not made a party, that's the problem.
It's not a big part.
Because everything will come from that.
No, in that even director of pension, replacement of 4. They'll.
No.
Not be like that.
It won't. It will have to come from your department, from that department.
That might have responsible 3. Commissioner secretary,
Not be like the department as such, without. naming
Okay,
any
what have I
department.
said? They accordingly submit that the issue with regard to whether the petitioner is entitled to.
Being a second wife.
Is petitioner is the wife of the late Jabar Ali Sarkar. May be decided by the irrigation department. And in this respect, the respondent number 3 may be allowed to authorize any competent officer to decide the said issue.
Yes.
Full stop. Next para. I have heard the learned counsel for the parties. In terms of the full bench judgment of this court in MUSTT Junufa Bibi versus MUST Padma Bigram alias Padma Bibi and co others, WA 160 of 2018, which was disposed of by judgment and order dated 22/12/2022, comma, Rule 143 bracket Roman 3 small of the Assam Service Pension Rules 1969. Acha, note 1, no, that's correct. And note 1 to Rule 143 bracket Roman 2 would have to be read to mean that family pension would be payable to the eldest of the surviving widows in the event of there being 2 or more widows. Further, in terms of the division bench judgment of this court in Sirajun Nessa versus State of Assam, 2011, 4 GLT 751. And MUSTT Khadija Begum versus MUSTT Regina Begum and 5 others, WA 244/2017. Even the second wife of a deceased Mohammedan employee would be entitled to family pension. However, the full bench in MUSTT Junufa Bibi Supra has held that family pension being payable to the eldest of the surviving widow or wife would not mean that the entire family pension so payable would be the personal property of the eldest of the surviving widow or wife. And the family pension so payable would be held by the eldest of the surviving widow or wife as a trustee for all such persons who are entitled to the benefits of the family pension in terms of Rule 143 of the Assam Services Pension Rules 1969. This is at page 38, para 22. Next para. As can be seen from the judgment passed by the full bench of this court in MUSTT Junufa Bibi, comma, a second wife in respect of a marriage of persons professing the Mohammedan faith is also entitled to a share of the family pension. The only impediment, the only issue is with respect to whether there is any dispute with regard to the petitioner being the wife. No, the only issue that might arise is as to whether the petitioner is the wife of the late Jabar Ali Sarkar. Usam. This aspect of the matter can be decided by the authorities after giving personal hearing, giving an opportunity of hearing to the petitioner and the respondent number 7. Usam. In the event that there is no dispute with regard to the petitioner being the second wife of the late Jabar Ali Sarkar, the family pension should be made payable to the respondent number 7, who shall thereafter give a proportionate share of the pension, family pension, to the petition. However, in case there is a dispute with regard to whether the petitioner is the second wife of the late Jabar Ali Sarkar, and the issue cannot be settled by the respondent number 3 or the officer deputed by him to decide the same issue, the petitioner shall be at liberty to approach the civil court. The writ petitions accordingly. The respondent number 3 and / or the officer deputed by him to settle to decide whether the petitioner is the second wife of the late Jabar Ali Sarkar shall give his decision with regard to the said issue within a period of
2 months.
2 months
From
from the date of receipt of a certified copy of the order. That is,
One thing here, the proportionate word is not used here, only the word appropriately mentioned is here.
okay,
Otherwise,
just say instead of proportionate, just say appropriate. The appropriate share.
Yes.
The writ petition is accordingly disposed of.
So here the petitioner was appointed as a my lord, assistant director in the town and county planning my lord. Prior to joining here, my lord, he was working in an autonomous body of the government, my lord. But that period of service is not taken for consideration of his my lord towards pension and everything. My lord.
What period?
The,
He retired as what?
no, he didn't retire, my lord. He's still working as an assistant director in the directorate of town and.
He is
country
working
planning.
as an assistant director.
Yes, my lord, in the town and country.
Where
town-
have you said that he is working as assistant director? Acha, under Directorate of Town and Country.
Yes, my lord.
So,
Prior to joining here, my lord,
yes,
I was working in Jorhat Development Authority,
yes.
which is a government autonomous body, my lord. And that period, my lord, that is about 10 years, my lord.
From which period?
From 2001 to 2010, my lord.
That should be counted
Yes, my lord.
for
That-
qualifying service for
Yes, my lord.
pension.
Yes.
So have you filed a representation?
Yes, I have filed a representation. my
So
lord.
that has not been decided.
Not decided.
Let it be decided.
Let notice go, my lord, because a similar case recently has been decided by the court, my lord, in similar circumstances, my lord. That is writ petition number that I have, my lord. That's why, my lord, notice may go at this stage,
No, I am saying, you see, because we are wasting time this way.
my lord,
Because if we direct them to decide
my lord,
by a speaking order
my lord,
within 1-2 months,
my lord.
because they will take at least another 6, 7 or 1 year to file a affidavit.
My lord.
So if they take a decision by a speaking order, then the entire facts are there.
But then in that case, my lord, lordship may fix it next week, my lord, because that order I have, he has not brought today, my lord. But that order was passed recently, my lord. Next week, any day, Monday.
No, you file a fresh representation.
My lord,
You file a fresh representation enclosing that order,
my lord,
and we'll tell them to take a decision within a period of 1 month
my lord.
or
But
6
that,
weeks.
That writ petition number I do have,
Huh.
but the order did.
No. You put in a fresh representation you submit
Fine.
along with a copy of this order.
But But that should be reflected in your lordship's order.
Yes, we'll reflect that.
Yeah, but that's why the date of the order is not available.
No, date of order is not
My lord,
required.
the
As long
petition
as the petition number is there,
Yes,
that's
yes,
enough.
that is available. my lord.
So that is, you just file a fresh representation. We
Fine.
tell them to decide that by a speaking order.
Fine.
And then within 1.5 months or something, everything is clear.
Fine, fine,
Then
fine.
you can come in a fresh
Fine.
representation if required.
Fine.
Otherwise, if you file this, you issue notice, they'll reply after 1 year.
My lord.
No point.
Fine.
That's what I'm just thinking for your petition.
My lord.
Right, heard Mr. N.J. Datta, learned counsel for the petitioner, who submits that the petitioner is presently working as assistant director under the Directorate of Town and Country Planning, Assam. Pusta. The petitioner's counsel submits that prior to joining the post of assistant director, the petitioner was the assistant director on 31/3/2010.
Right.
The petitioner was working as sector inspector in the Jorhat Development Authority from 13/3/2001. Thereafter, he was promoted to assistant engineer in the Jorhat Development Authority on 29/11/2002. And he worked
In pursuance to an advertisement.
and he joined the present post of assistant director in the Directorate of Town and Country Planning, Assam, in pursuance to an advertisement. Next paragraph. The petitioner's counsel submits that the petitioner's service under the Jorhat Development Authority should be considered as qualifying service.
Yes.
For the purpose of pension. In terms of under the Assam Service Pension Rules 1969. Petitioner's counsel submits that the present case is a covered case in terms of the order passed in WPC number
1680 of 2012.
1680 of 2012. He submits that in view of the present case being a covered case, the respondent authorities would have to count his past service in Jorhat Development Authority as qualifying service for the purpose of pension. He also submits that though the petitioner had submitted a representation dated
28 November
28/11/2011. Oh, dude.
and which was already forwarded page 29.
Huh?
Objection with regard to delay in assessment.
No, how does it matter? He's not resigned as yet.
After 2007.
I am still working. How can I
Doesn't matter, he's still working.
I'm
He
still
has not taken a decision. That's why a fresh application. What?
but subsequently it was forwarded
He
on
also submits that the petitioner submitted a representation in this regard on 28/11/2011, which has not been decided by the authorities till date, despite the said representation having been forwarded by the Director, Town and Country Planning, Assam, to the Under Secretary to the Government of Assam, Urban Development (T) Department, Dispur, wide letter number TP/EST/11/2010/21, dated 11/1/2012. Full stop. Next paragraph. The petition counsel submits that the present writ petition can be disposed of if the respondents are directed to dispose of the petitioner's representation dated 28/11/2011 or give liberty to the petitioner to file a fresh representation with regard to the prayer made in this writ petition.
Fine.
So stop. Next, Mr. D. Bora, learned counsel for
1, 2, and 4.
1, 2, and 4, and Mr. A. Chaliha, learned counsel for. That's point number 3. Submit that they do not have any objection.
Possibility that the order might have been passed,
That do not have any objection to the prayer made by the petitioner's counsel, provided the same has not been disposed of order. Provided the petitioner's representation dated 28/11/2011 has not been disposed of order. On considering the submissions made by the counsel for the parties, this court is of the view that the petitioner should be, that this court is of the view that as the petitioner's earlier representation has not been disposed of, as the petitioner's representation dated 28/11/2011 has not been disposed of by the state respondents, and keeping in view the fact that the petitioner is still in service, as on date, the you cut, then after as on date, the petitioner is given the liberty to file a fresh representation with regard to his grievance before the
Respondent number 4.
respondent number 4, who shall take a decision on the same within a period of 1 month from the date of receipt of a certified copy of this order. Full stop. The same is however, the above direction is however subject to the condition that the respondents have not taken a decision on the petitioner's representation dated 28/11/2011. Full stop. If a decision has already been taken on the petitioner's representation dated 28/11/2011, the decision taken should be communicated to the petition. The written petition is accordingly disposed of.
I am offline.
May I please do that? Here the petitioner retired from service as senior assistant from District Elementary Education Officer Golaghat on 31st/10/2019. His pension has been already finalized by the SDO and PPO also has been
Issued.
Lordship. All the other benefits, gratuity, leave encashment, everything is paid Lordship, except
Pension.
monthly pension Lordship. Due to non-furnishing of a certificate by the District Elementary Education Officer, that is royal and non-royal certificate Lordship.
Royal and non-royal, sir.
Non-royal certificate by the District Elementary Education Officer Lordship. Due to not furnishing the certificate Lordship, its monthly pension has not been paid. Even Lordship, provisional pension has not also been paid since 2019. Lordship.
Yes.
Otherwise, there is some issue regarding my lord, audit observation, page 22. This is the region, my lord. The royal and non-royal certificate would not be issued, my lord.
Yeah.
There are some discrepancies in maintaining the cash book during his tenure. So SOPOS was issued to him, and he could not furnish the
But he
details, my lord.
he has already replied.
No, you see, one issue is he retired in 19.
2019.
4 years have passed.
Yes, my lord.
Is there any criminal proceeding against him?
No, my lord.
No, Lord.
Is there any DP against him?
Apparently not.
No, Lord.
If that is the case, can the pension be
No.
denied to him
No.
as per rule 21?
21, Lord.
No, my lord.
End of the matter. He has to be given.
Yes.
You cannot go into this issue.
Yes.
So we'll direct that it should be given. What remains?
Nothing good.
But
Better, my lord. No, my lord. I have no specific instruction from the
Ah.
department. I have just submitting from the
from the
petition, my lord. So my lord may give me 1 week time so that I can obtain the complete instruction. On next date, my lord may dispose
only
of-
thing, only 2 instructions. Whether DP initiated, whether criminal case is there.
Yes.
Because DP for criminal case also 4 years is
4
the
years.
time limit. 4 years is gone. 4 years is gone. Because now is November.
Yes, my lord.
4 years is gone. DP you have not initiated, you cannot initiate now. So let him take that instruction then. Any departmental proceeding initiated against you?
No, Lordship.
Any,
Just Lordship, this letter, Lordship,
Uh.
requesting some clarification,
oh,
and I have clarified, Lordship,
okay.
my reply.
Okay.
Some
Yes, there's nothing.
No
there's nothing.
allegation is there, Lordship, no
Why should we
misinterpretation.
keep it pending
Nothing.
actually? This is 11/9/23. It's not your case.
In this letter, nothing, Lordship, some clarification, Lordship.
Right. Right, Mr.
Okay, that's
P.K. Das, learned counsel for the petitioner, who submits that the petitioner retired from service, no, from the office of the district elementary education officer, Golaghat, on 31/10/2019, where he had worked as senior assistant. Full stop. The pension papers of the petitioner was duly submitted by the respondent number three,
Three, my lord, three.
sorry.
to the Office of the Accountant General, Assam, by letter dated 27/8/2019. And the Office of the Accountant General, Assam, finalized the pension proposal of the petitioner. Full stop. Pension payment order bracket PPO right close number 913-211-260-455 was issued by the Office of the Accountant General, Assam, to enable the same was issued by the Office of the Accountant General, Assam, and the same was duly communicated to the Treasury Officer, Golaghat. Full stop. Next para. The petitioner's counsel submits that though all the other pensionary benefits payable to the petitioner have been paid to the petitioner, the petitioner has not been paid his regular monthly pension. Full stop. The petitioner thus prays for a direction to be issued to the respondent to pay his regular monthly pension. No, before that. What have I said? Before that. My monthly pension due to the respondent number 3 not issuing the non-drawal, drawal/non-drawal
Certificate.
certificate. Where is that? Where is that?
Lordship, there is a prayer, Lordship, to, Lordship may see, page 15, Lordship. This is PPO last para. Page 15, Annexure 2. Yes, certificate.
Drawal/non-drawal certificate regarding provisional pension/. Family pension/gratuity. Has not been issued by the respondent number 3. Correct?
Lordship.
Next paragraph. The petitioner's counsel submits that the respondent number 3 had issued a letter dated 11/9/2023 to the petitioner regarding some clarifications to be made in respect of the cash book and the cash that was kept in the office of the DEO,
DEO.
kept on the office of the respondent number 3. Full stop. However, the petitioner by letter dated,
9/1.
how can it be 9/1? Let the 9/1 is January.
Sorry, sir. 9/11, Lordship.
9/11. No,
On
page
the
26.
particular, my lord, it is 22/9.
22/9, so final
Uh,
26.
The letter dated 22/9/2023 had clarified the issue while making a reply to the respondent number three's letter dated 11/9/23. The petitions council thus submits. Now, the petitions council submits that as there is no departmental proceeding initiated against the petitioner, departmental proceeding or criminal proceeding initiated against the petitioner till today, and as all the issues that needed clarification having been clarified by the petitioner, the respondent number three should be directed to issue the drawl/non-drawl certificate, and respondent should be made to pay the regular monthly pension to the petition. Next paragraph. Mr. N.J. Khatania, learned counsel for the
Education Department, my lord.
Education Department, and Miss
J Das for respondent number 4.
J. Das for respondent number 4. Submit that there were no there were no comments to make, in as much as they have not, in as much as they have not received any instructions in the matter. Correct? I have heard the counsel for the parties. Rule 21. Of the Assam Service Pension Rules 1969 provides that
B, Lord.
the whole or part of any pension can be withheld provided can be withheld for the purpose of recovery of any pecuniary loss caused to the government, if the government servant is found guilty of grave misconduct or negligence during the period of his service in any departmental or judicial proceeding. However, in the present case, no departmental proceeding has been initiated against the petition, even till today. That is more than 4 years after his retirement. Rule 21 bracket C of the Assam Services Pension Rules 1969 provides that no judicial proceeding shall be instituted in respect of a cause of action which arose or an event which took place more than 4 years just write it. No judicial proceeding, if not instituted while the officer was in service, whether before his retirement or during his re-employment, shall be instituted in respect of a cause of action which arose or an event which took place more than 4 years before such institution. Full stop. In the present case, despite the petitioner having retired more than 4 years ago, comma, no criminal proceeding has been initiated against the petition. As such, there is no justification for the respondent number 3 not to issue the draw slash non draw certificate to the petitioner. As is required in terms of the letter number PR-2/EDN/13/062352/2019 dated 19/11/2019 issued by the senior accounts officer, comma, Office of the Accountant General, bracket ANE, bracket close, comma, Assam, and addressed to the Treasury Officer, comma, Golakand. Page 15 of the report. In view of the above reasons, comma, the respondent number 3 is directed to issue the draw slash non-draw certificate immediately and submit the same to the Treasury Officer Golakand, comma, to enable the petitioner to receive his regular monthly pay. The rate petition is accordingly disposed of.
Obliged.
My lord, in this case, the petitioner retired from the service on 30/11/2020.
30/11/20,
20 as
3 years ago.
as Joint Director, Information and Public Relation Officer. 30/11/2020. Now, prior to his superannuation, 3 years before that, disciplinary proceeding was initiated along with the director. Director was the male. Now, director misappropriate 30 lakhs amount. I just narrate instead of going and showing the paper. 30 lakhs an odd amount, but director 30 crores something odd amount. But director, my lord, what has happened in his finding, there was no finding against him. And ultimately, compulsory retirement with full benefit. I am only aid and abettor.
Yeah.
Aid and abettor. Aid and abettor. This is one aspect of the matter. So far, director main allegation is there. Now, my lord, disciplinary proceeding was initiated against me prior to the superannuation dated 30/11/2020. Now, once the disciplinary proceeding was initiated, so cause was issued, inquiry officer was appointed, presenting officer was appointed. In the meantime, I superannuated. Now the position under 21, Rule 21, initially was that you have to take permission from the governor, but subsequently in the explanation, it becomes automatic after retirement, once the disciplinary proceeding was initiated. Now, there is one judgment of the Supreme Court which came latest on 12th of October 2023 by division bench of the Honorable Supreme Court, which I found yesterday. And it is said there was a regulation which was put to challenge. What that regulation was? Banking regulation of Bihar. That's the facts of the case in that case. That disciplinary proceeding initiated, so cause was issued. Thereafter, the person retired. In the regulation, it says, once the disciplinary proceeding is initiated, you can't retire. The disciplinary proceeding has to be completed. Now, that person, superannuated was not allowing it. Now, it is traveled up to the apex court. Now, the apex court view judgment was that you can initiate a departmental proceeding, disciplinary proceeding, these are preliminary inquiry. After superannuation, if a charge memo and charge sheet is not filed, everything will go. The regulation also will go. This is a point, my lord, which was ever raised before this honorable court. This is the judgment which I found. It is judgment. Yesterday, my learned friend, he just helped me with the judgment. Yeah, I also was, I knew, my lord, automatic. 21 is becomes automatic. But here, my lord, when it's very nice,
Para?
Para, my lord, 21, kindly see, my lord, para 21. First see 24 kindly see, then I will go 24. I'm going reverse, my lord. 24. Because there were two judgments of this court, Rajinder Kapoor 1, Rajinder Kapoor 2. Now kindly see 24, man. From the aforesaid referred judgment of this court, especially by a larger bench, consisting of 3 judges in our opinion, there is no merit in the present appeal, as the principle laid down therein have been followed by the High Court. This is the Union of India as right. In the case in hand, the deceased employee has attained the age of superannuation on 31/7/1991, whereas the charge sheet was issued to him on 7/12/1991, meaning thereby that on the date of his superannuation, no disciplinary proceeding was pending against him. So now, my lord, now you come kindly turn to para 21. Kindly see para 21. While interpreting the 1979 regulation, the court opined that the legal fiction created in clause 3 of sub-regulation 23 of 1970 regulation must be given full effect. But it is well settled that the scope and ambit of legal fiction should be confined to the object and purpose for which the same has been created. It was opined that 1979 regulation could be invoked only when the disciplinary proceeding has been initiated prior to the ceasing of the employee service. Delinquent employee would be deemed to be in service although he has reached the age of superannuation only if a valid departmental proceeding has been. Now this is important. Departmental proceeding was not initiated merely on issuance of a so-called notice. It is initiated only when a charge sheet is issued. That is the date of the application of minority allegation level against employee by the competent authority. Pendency of a preliminary disciplinary by itself cannot be a ground for invoking of regulation 20 of 1979 regulation. Now see, my lord, this 21, which they brought it by an explanation, automatically it will continue only when now an inquiry officer is appointed in my case. Now inquiry officer, my lord, has to file a charge memo against me. List of witnesses.
You see, there's a slightly vague area out here. Sometimes the courts say memo of charge sheet. Sometimes they say show cause notice. So they sometimes these
My
words
lord,
are very
please,
confusing.
So, my lord, please let us, my lord, with great respect, please do not mix up with a so-cause, which is a preliminary with regard to the charge memo.
Okay, so yes, so that is what. If it's preliminary, then it's
Preliminary
then the
so-cause,
different.
it goes on. But again, when they, my lord, when an inquiry officer is appointed, they will give a memo of charges. That is what you have to give a reply.
Correct. No, but then you see what happens is in a preliminary inquiry, you don't need to give a show cause. It's a preliminary inquiry.
Preliminary inquiry,
Ah.
which, my
So-
lord, normally what happens when a preliminary inquiry, they issue a so-cause in a preliminary inquiry. We give a reply. Inquiry officer is appointed. Inquiry officer is appointed. Then the presenting officer. Now your inquiry officer, your lordship, they will issue a memo of charges. Now what the Supreme Court is saying,
The inquiry officer will.
then it's really disciplinary proceeding starts.
No, I don't
One
think.
the
I
inquiry
don't think the
officer-
inquiry officer will. No,
No, no,
it
no,
will be the disciplinary authority which.
no, no. What, my lord, then only, my lord, there has to be charge memo has to be issued.
No. That is what sometimes they. I find even in Assam.
Yes.
They sometimes mix up. Though it should have been a memo of charge, like
Yes.
you said, which has to be issued.
Yes, right.
They issue a show cause notice, assuming that the same to be
Yes.
a memo
Right,
of charge.
absolutely correct. Your lordship is right.
So that becomes confusing.
All confusing.
So now when you read this judgment of the Supreme Court, you have got to consider that in terms of the practice
Yes.
available in
Right.
this state.
My lord, what I was trying, first I thought yesterday, before yesterday when it was briefed, I was thinking of second leg of argument. I thought your lordship will remand this matter because there is an inquiry. The departmental proceeding was initiated. That I thought. The departmental proceeding was initiated as director. My lord, director case, because he's a main. I can show it, my lord. He's a main, but compulsory retirement, nothing was filed in charge memo number 1. He got full pension. My is that what I'm getting a provisional pension. I'm not getting it. That's why I approached this court. But when I found a judgment, I thought I should place before this court. And there is one judgment of this court, after the explanation of 21 of this court, which was passed, my lord. They said these are 300A. So you cannot retell till the inquiry, whatever may be, this you have to release it. Because it was relied on a judgment passed by an apex court in some regulation of Bihar 43A, which is a parameter with this. So these, I think, my lord, your lordship, as a legal provisional, I should get, I request that your lordship, we should get the full pension. But I think this is the area where your lordship should decide the issue. So I thought that I should point it before your lordship, because 21 explanation is automatic. Earlier, one judgment of this court is saying an order of the governor has to be there. Order of the governor. Even if a continuance also, there has to be an order of the governor. So they make an explanation saying it becomes an automatic. Now, if you see automatic, so what I understand, even a so cause notice, which is issued to us, that also becomes.
I don't think it's automatic. I think it should, there should be an order, I think.
No, that's what, there is order, but what I find, kindly see, this is why that made that explanation.
Anyway, can we decide this?
No, today you can, your
Whether we
lordship
should
cannot
notice
decide. But I only request, humble request, your lordship, that this person is getting a provisional pension. If it can be expedited from the government side also.
That will depend upon it.
No, that's why I'm saying.
My lord, he is getting provisional pension, my lord.
But
This is-
provisional
this is-
pension
this
is
is-
not
this
you
is-
can't.
This is a case of, my lord, corruption, my lord.
No, you
Public
have-
money. So, my lord, that is always there, my lord. So, my lord will-
No,
if
it's
you notice,
okay.
my lord, we'll file our affidavit. Yes, my senior wants it little early. I will try to file my affidavit little early.
My lord,
That's it.
charge has been dropped against the main director. Aid and abettor, main director, it's have been annexed there. Main director charge has been dropped. And you have asked him to go for compulsory retirement, giving full benefits. I aid and abettor and you have withheld me. Only a provisional pension. That's why I have approached this honorable court. Let him file a reply, short reply, whatever he want to do. Kindly see, my lord, page
My lord.
73, my lord, kindly say
My lord,
73.
grant us at least 4 weeks time.
Kindly say 73, my lord. Recommendation charge, last paragraph at page 73, my lord. See, last two line kindly see. This is charge number 130 crores at starting at 71. Kindly say 73, last paragraph. Recommendation, charges framed against delicate officer is not correct. Include a hand for avoiding a repetitive nature of charge, this may be dropped.
This is not complete. Your page 73 is not complete. We cannot read the bottom part. One line is missing.
We'll bring it back to every.
Change this page.
Is an item.
He has retired in 18, that focus was of 2018, retired in 20. And now he is before my lord in 23. So he can wait another few months, my lord.
No, he doesn't have any money.
Provisional pension. Who made the money? Who made the money?
But in paper, my lord, it shows the 30.26
It
crore.
will always
So,
show.
the case projected by the petitioner is that building has collapsed. Head mystery is acquitted. The second mystery is made responsible. Anyway,
No, I thought that I should place the judgment of the apex court,
Ah.
which I found in 2023.
we'll,
All these three judgments was placed.
I'll have to read this.
Yes, your lordship can go through the judgment. Your lordship is right. There is some confusion here in this one, in so-called charge of memo, charge sheet.
No, but because even the Supreme Court, you see, in some judgments has stated that the requirement of giving two show cause notices. Without speaking of a preliminary show cause, it talks about the memo of charge being a first show cause and the inquiry report, giving of the inquiry report being the second show cause.
Yes.
So the Supreme Court also sometimes interpolates or interchanges those words, memo of charge and show cause notice. So it becomes very confusing for us.
Memo of charge and
Right.
Right, third Mr. Dida, Colonel Senior Counsel for the petitioner who submits that while the director of INPR has been acquitted, has been dropped,
Has charge been dropped.
has
Charge
been
number number
discharged,
one.
has been
Main
discharged,
charge.
has
Charge
been
number one.
attacked. Well, just say that heard Mr. D. Ras, Senior Counsel for the petitioner who submits that the petitioner that a departmental proceeding has been initiated against the petitioner, who is the joint director INPR. Full stop. while the director INPR, while the charges against the director INPR has been dropped, comma, the petitioner has been charged with abetting,
Aid and abetting. in respect
aiding
of
and
this
abetting the director
separate- Charge number one. This separate.
in respect of charge number one. Issue notice are returnable in 4 weeks. Mr. R. Dar accepts notice on behalf of point number 1 to 5. That's all. Mr. R. Dar shall submit his affidavit in opposition. List the matter on when. You give it,
Second week of January.
give it.
And moreover, there is no criminal case against me. Criminal case is against director. No criminal case against me. Neither I was placed under suspension. Director was placed under suspension. All these are there.
And director criminal case is there.
Yes, against director, not against me. I will change that particular last year. Also will give that liberty to change that
Yes,
last year.
says that the page number 73
73,
may be changed by the petition
yes. I am deeply obliged.
as it is not complete.
Field officer case.
Same minute.
Same order parcel. Wait, out here the parties. Mr. A. Goyal is there. Then Mr.
Yes, sir.
S.R.
Borua,
for
response number 1.
1.
Lost it.
S.R. Barwa. S.R. Barwa. And for 2, 3, 4, Mr. S. Datta. And for 5, M. M. Bhuya. M. Bhuya for BOI. Okay, fine. Everything is same, no?
Same.
Exactly.
My lord, our prayer, my lord, base 15, my lord.
Page
My lord,
15.
My lord, here I need some accommodation, my lord. That inquiry, status of inquiry, my lord, was sought for. We have written few letters. On the last.
Status of DP.
Yes, my lord. That is not forthcoming.
I
my
think
lord.
that's required.
My lord, since long, my lord, it has been, my lord, personal appearance may be ordered, my lord. Last time, he also had prayed for a direction for personal appearance. Because they are not responding to his letters. He is helpless. They responded, but it was not complete. They sent something.
Now what to do? Do we ask for personal appearance?
No, my lord, I will take it.
You take it.
My lord.
Okay, Mr. Ardar, take for one more chance to enable him to receive instructions with regard to the status of the disciplinary proceeding pending against the petitioner. Prayers allowed. One last chance is provided to Mr. Ardar. List the matter on.
My lord, may indicate that otherwise.
One last chance is provided to Mr. Ardar to provide to receive the instructions, failure to make submissions with regard to the query raised by this court will entail the personal appearance of
He has written letter to. My lord, it will be Commissioner Secretary, Housing and Urban Affairs Department.
of the respondent number 2 before this court. List the matter on.
My lord. December 12th, my lord.
3rd December.
Obliged, my lord. Obliged.
Yeah, please, Lord. Here the petitioner, the retired person from Coal India Limited. But his pension has been stopped by the order passed by a executive magistrate. Also, may see the order dated 4/4/20.
Who is the government who is appearing here?
And that person, Lordship, who instituted the case, Lordship, on which favor the inquiry order was passed, already dead, Lordship.
I know, but then where's the council?
All India. T. Supriya.
T. Shutia is the senior government advocate. Mr. R. Sharma had appeared.
R. Sharma appeared. All India.
Respondent number 1 and 2, they are the persons required as per the last order.
It's not a matter of state.
This order passed by this executive magistrate. Actually, that it's a very wrong order. But then anyway, state being granted, and the Oil India was supposed to in the meantime give whatever his prayer. But he's not here. Can you call him?
But let's say, by this order, let's say, they should have paid the.
Correct, they should have
but,
paid.
After, this, let's say, supplying this,
Mr. Council, the problem is that council is not here. Now I have to ask him, why have you not paid? Now to give a direction. Or to tell him, ask him why it has not been done. He's not here. What to do?
maybe before, let's say,
Let the madam come up next week, madam.
Right. Mr. P.K. Das appears for the petitioner, while Mr. Ardhar appears for respondent number 3. No one appears for respondent number 1 and 2. Full stop. This court, in the order dated 4/4/2023, had directed the respondent number 1 and 2 to do the needful in view of the order dated 15/12/2020, passed by the SDM Executive Magistrate, Margarita. Passed in PG case number 1 of 2021, having been stayed. However, in the absence of the counsel for the respondent number 1 and 2, there is nothing to show as to whether the respondent number 1 and 2 have been have done the needful, have done the needful. Accordingly, in the interest of justice, list the matter on when?
next week,
Give a date, You give a date.
Thursday or Friday, let's say, Friday.
Any day.
Thank you.
If you find him, bring him.
Obliged, Lordship.
Made the Lordship. Since the petitioner has retired and his pensionary dues has remained unpaid, your Lordship. Housing note,
So, para 5.
Para 5, page 21. 21, Lordship.
So it has to be done as per this.
Now, they have
And
made a
then-
proposal
That
of,
is their proposal. So are you agreeable?
with a little bit of modification, your Lordship.
How much?
They are saying that they will give it in 12 months. I would say that equal installments in 6 months. Because my daughter is studying and I have instruction that she is studying in Delhi for higher education. We've got some. That can help.
Lordship, due to the acute financial condition, that's why we made this type of affidavit, Lordship.
What about 1 lakh per day, per month? This will be a difference of
Lordship,
only.
Lordship petitioner will get 91,666.66 per month. Lordship, more than this amount, Lordship, will be in big trouble actually, Lordship. Because
You
of,
accept this, what is it? It is better, 1 bird in hand is better than 2 in the bush.
Lord.
Am I? Yeah. Okay, right. Heard. Mr. M.H. Laskar, learned counsel for the petitioner.
Mr.
as well as Mr.
E.R. Gogoi Lordship.
T.R. Gogoi learned
Sole
counsel for the all the respondents,
Sole respondent,
For-
Assam State Housing Board Lordship.
for the two respondents,
Two respondents.
for the respondents. The petitioner's case is that he retired as a sub-engineer, grade 1, from the office of the ZHO. What is ZHO?
Zonal Health Office.
Zonal
Health Office.
Health
Assam State
Office.
Housing Board.
Assam State Housing Board, Silchar, on 31/12/2022. Full stop. However, his retirement dues amounting to rupees 12,05,721 have not been paid by the authorities. Next paragraph. Mr. T.R. Gogoi, learned counsel for the respondent, submits that the total dues payable to the petitioner was initially 14,27,502. However, as an amount of rupees 2,45,544 has already been paid to the petitioner, the outstanding retirement dues payable to the petitioner as on date is 11,81,958
Yes.
and not rupees 12,05,721.
Lordship.
Full stop. The petition, the counsel for the respondent submits that in terms of para 5 of the affidavit in opposition filed by the respondents number 1 and 2
Lordship.
on 6/11/2023, the respondent authorities would be capable of giving the entire dues of the petitioner within installments. In how many installments? In
12 installments.
12 installments.
Within this month, we will pay 81,958 Lordship within this November.
Keeping this amount in 12 installments, remaining amount.
Remaining
No.
amount, remaining
81 is on or before 20th October.
That date is already gone here.
Lordship.
So within November, they will pay it, and from December onwards, they will.
Lordship, within November, Lordship. There's a mistake, Lordship.
Okay, what have I said? Installments starting from October. No, not starting from, the first installment being paid on or before 20th November
Lordship.
2023.
Lordship.
This is not
Oh,
first
full
installment, your lordship.
He submits that though para 5 of the affidavit of the respondent gives the date 20th October 2023, the same should be read as 20th November 2023. Correct?
Correct.
Full stop. Thereafter, for every succeeding month from December 2023, the petitioner would be paid rupees 91,666.66
Lordship. Yes.
by the 7th of each month.
Yes.
By the 7th date of each month.
For the next 12 months. Now, because this amount, the first amount they are giving, and then there will be 12 installments.
Yes.
After giving the first amount of rupees 81,958, the remaining balance amount they will give in 12 installments.
Total will be 1181.
Total will be 1181.
That's fine.
81 will be given in this month.
Correct. 81 this month. Thereafter,
Yes.
91 till you give the every month.
Lordship. Lordship.
Next paragraph. The petitioner's counsel submit that the petitioner is the petitioner accepts the
My submission
The-
will be recorded here, what is that I made it there for six months.
the petitioner's counsel submits that though the petition council submits that the petitioner should be given. Should not, submits that the entire retirement dues of the petitioner should be paid within 6 months. So, on considering the submissions made by the council for the parties, this court is of the view that the proposal put forth by the respondents should be accepted. So accordingly, the petition, the respondent number was 1 and 2 are directed to deposit 81,958. No, are directed to give, no, directed to give 81,958 to the petitioner on or before 20th November 2023. Full stop. Thereafter, rupees 91,666.66 should be given to the petitioner on or before the 7th of each succeeding month. Lord. Till the entire amount of rupees 11,81,958 is given to the petitioner. Lord.
If you want one thing, I'll provide the details of my bank account. That may be because
Full stop. When will you give today?
I'll provide
Mr.
MH first.
M.H. Laskar, learned counsel for the petitioner, shall provide the details,
Bank details.
shall provide the bank details, bank account details of the petitioner. Not your account, no, the petitioner. Of the petitioner. To Mr. T.R. Gogoi, learned counsel for the respondent
In the course of that.
within the course of the day.
The amount shall be deposited in the account.
So the amount to be given by the amounts to be given by the respondent shall accordingly be deposited into the account number provided by the counsel for the petition. So the writ petition is accordingly disposed of.
Obliged.
You take this also. Yes.
So two issues, Lordship, yesterday two issues were raised, Lordship. First is gratuity, Lordship.
Yeah.
If the person concerned is Lordship state government employee,
Ah,
then Lordship the gratuity act will not apply, Lordship, rather Lordship pension rules will apply, Lordship. I have gone through the provision. I refer the provision of 135, that will apply, Lordship.
for state government.
Yes.
If it's central government employee, then payment of
Yes,
gratuity.
Lordship. And one of the case, Lordship, last year I have, this is reported also in my case, Lordship. 2022 1 year.
What does it say?
It says 135 will apply,
Okay, then
along with interest also interest.
Then-
And the other is a leave, it will cover by leave rule, Lordship.
leave, but that is for state government,
First state.
for the state government
Yes,
employees,
this one first state government.
for commutation, no, for early,
All leaves are here. Lord.
all leave.
Commutation
And what
is
about
first.
for central government?
Central government also there different rules will be here. For state government also is state.
Okay. So anyway, gratuity, you have got to have at least 5 years of service
Yes.
minimum.
Plus
How many years of service do you need to have?
petitioner.
Any person who is,
5 years,
Right.
minimum qualifying is 5 years.
and it has to be calculated on the basis of the last pay drop.
Last pay term, Lord. Calculation is also mentioned the pension payment. Pension.
Okay, good. Okay.
I'm sorry, Lord, yesterday I was.
No, it's okay, sir. It's a learning experience for everyone.
Yes, yes.